Good morning, welcome back. This is Daybreak and thank you for staying with us. The hashtag on X is Daybreak, the SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. This morning with me in studio, Demas Kiprono is the Executive Director, ICJ Kenya. Good morning.
Good morning.
Thanks for your time. Lovely to have you here on the broadcast. The only lady of the morning is Elizabeth Tanoi. She is the Deputy Registrar, the Court Automation Services. Good morning.
Good morning.
Thanks for making time for the broadcast.
Thank you.
Much appreciated. And Duncan Okaj is an advocate of the High Court of Kenya. Good morning, Wakili.
Good morning.
Much appreciated for your presence here.
Thank you so much.
Let's talk about the automation drive and the leveraging on ICT, which is a key driver, according to the Chief Justice Martha Koome, who on the 11th of March this year had talked about that by extension. And I just want first to begin with you, Elizabeth, and leading this very own course or being part of the team that is meant to deliver on this. How will this then make the third arm of the government a responsive unit of our architecture of government and tailor-made to the needs of the people that it serves?
Thank you so much, Ayub, for having me this morning. So thank you for that question. The judiciary basically is an arm of government which is supposed to help people in terms of resolving their disputes. Yeah. So it's central in terms of access to justice. But if you remember, Ayub, for the longest time, we have had our processes and our systems being very manual, and people had to come to court. So one thing that drives the digital process is access to courts, access to justice. And when you're talking about access to justice, there are many things that you're talking about. You're talking about people's sense of their own responsibilities and rights under the law. So you need people to understand the law. You need people to be able to resolve their disputes. You need people to be able to access these particular institutions which resolve their disputes. So before the digitization process, we had to, drive all the way to court process, to court institutions. You had to come to the registries. So in terms of digitizing and driving this digitization process, we are just basically having an opportunity to reduce the distance to court so that people can access justice. And distance to court might mean distance to the registries, because you see, the life cycle of a case has to start in a registry. You have to initiate a case. So that if you have to initiate a case, why do you have to drive all the way to a court institution to lodge your complaint if you can have that at the click of a button? So that is the entire, issue of digitization, just to reduce the distance to court and to improve access to justice.
All right, and that case, then you paint a picture of an efficient judiciary.
Exactly.
But what also now is part of that conversation, Demas and Wakili Dan, you agree with me, is also the extent with which all Kenyans then understand the system, the aspect of literacy, and now this being rolled out across the 47 devolved units across the country, then how well do you also carry out that awareness and sensitization for example, Demas's mother or Dan's grandfather or my mother, who I suppose speaking good English will be difficult to understand the dashboard, the caseload aspect, and we'll talk about that. Wakili, coming to you, Dan.
Yes.
The CJ on the 11th of March, just a few days ago, had talked about the e-filing beyond Nairobi County and the rollout in the county of Mombasa, and the 13 were already onboarded, making the total about 34 counties, only 13 minus the 47 counties. This is a significant proportion or number that the third arm of the government targets in terms of making Kenyans easily access justice and follow up their cases. But how efficient is this in terms of the delivery and working in terms of on the timely basis, the understanding, the simplicity of the process, and are these factors that have been considered throughout this process in your view?
Thank you so much, Ayub, for having me and for having this particular topic. It's quite important. To your question, of course, the backdrop or the essence of e-filing is that aspect of access to justice as guaranteed under Article 48. In fact, it is not specifically a duty of the judiciary of the third arm. Article 48 says it's a duty of the state to ensure there is access to justice. Moving it further in terms of how have we decided to increase access to justice through this e-filing process? To a large extent, the elites and the digital generation are able to easily interact with this particular platform. And indeed, there is no question about that, because we've seen people even filing their own cases, left, right, center. However, the bigger question then comes in terms of how does it make it easy for a common person? A person like you are saying, the grandmothers, the people who are in places where there is less internet connectivity, how does that impact on them? And I've seen in the judiciary has tried to put, you know, an aspect whereby a tutorial, which can teach people how to access. The tutorial itself is in the English language. There is no translation to the Kiswahili language or maybe to other mother tongues to make it easier for other people to interact. But I say Rome was not built in a day. So this is a journey that I think, and they're open to our views. And those are some of the things that will help us ensure that there's access to justice. But moving forward, we have a society that is more and more digital. You know, there was a time, I remember, when there was the introduction of digital airing of your programs, and there was a big issue. Do we remain analog? Do we remain digital? Everyone has swiftly moved on. So I think it's an idea whose time has come. Challenges will be there, and there are several challenges with this. I think you'll give us time to also speak about that. But it is a step in the right direction.
Okay. Demas, how transformative is this a step in the direction of, for example, that the organization that you do represent, that seeks justice for all? How transformative is it as a step?
I think it is very transformative. First of all, looking at the background, the system was designed around before 2020, actually, before COVID. But it could not come at a better time when access to justice had to go online for us to control the spread of COVID. And so, first of all, in that respect, it was very timely. And then we have to realize that in Kenya, more and more services are going digital. The judiciary has followed what the executive has done in terms of service delivery. And we see this as transformative. Obviously, there are going to be infrastructural issues, such as access to the internet, persons having actually the gadgets or the computers that can allow them to access this justice. But we have to find ways of accommodating everyone. And so as we laud these e-filing systems and other online our digital solutions, yes, we say that there are issues of inequality that need to be addressed. However, that does not stop us from continuing with this journey of giving people access to justice no matter where they are. Africa is known for its laid-back approach to technology, but Kenya has shown that it is ahead of other countries. We are also called the Silicon Savannah. We are, I think, leading in terms of persons who do crypto investment and so on and so forth. So I think it is timely that we allow people to access justice the way that the e-filing system envisions, but we should also keep a lookout for instances where persons, because of who they are, or because of where they are, cannot access these same tools. How do we bring them on board? How do we ensure buy-in by all persons? Because digital solutions have to get buy-in for them to be used. Even issues such as M-Pesa, initially when they came in, people did not believe that you could have real currency or real money moving through a phone. But sooner than later, it became the model of transactions. And here we are seeing that this system is also cashless. All transactions are made through M-Pesa, which means that it also removes certain avenues of abuse or corruption. So all in all, it is really a game changer. It is a game changer that is going to the counties. We must think about accessibility issues.
Elizabeth, in aligning this to the social transformation through access to justice, which is a blueprint for the judiciary, how has the pandemic, COVID-19, made a case, for that matter, that yes, despite being in the midst of a pandemic that many of us had no understanding about, inundating our healthcare system, shutting down the global economy, that still justice could be accessed by Kenyans? And how then does this add up to the already existing responsibility of being a transformative justice system that is responsive as well to Kenyans, with no regard for where they are, whether in the country or outside the country?
Thank you, Ayub. I think when answering that question, I want to look at it in terms of, looking at this institution, which is really trying to be independent, at the same time strong. So when you look at the social transformation through access to justice, the Chief Justice is looking towards building an institution which is strong, independent, but at the same time which is accessible. So you can have a very strong, independent institution, but it's not accessible. People do not understand the processes, the procedures inside there. So I think for us, of course, the COVID-19, despite, the pain points that it brought, was actually it has its own silver linings in terms of the benefits that it brought. So as my colleague here has said, these particular initiatives were in the pipeline even before the COVID-19 pandemic. But, since time immemorial, we have been paper-based, and we have been, so used to our physical infrastructures. So that the COVID-19 then gave us an impetus where we scaled down our operations. So people couldn't come to court. The idea was, how do you still have justice run despite the fact that people were at home? Cases had to be heard. There are many cases that we have. So that then gave us an opportunity to, roll out these particular initiatives. And as he said, we rolled it out when, we had difficulties. It was a system which had not been fully built. This is a system which is internally built. We haven't bought the system from anywhere. So we have built the foundations of this system from, the brick by brick. We have built it. And at the time we were rolling it out in July, it was not a fully, enhanced system. It has its own challenges. So at that particular time, of course, we tried. And because we did not have another opportunity of accessing court, we had to swim in this particular system. So it gave us an opportunity to try it out, to improve it, to enhance it, and together, even with the lawyers, we were able to build the system to the time that it is now. So yes, COVID-19 gave us an opportunity to, enhance access to justice. It helped us build this particular system. It would have been difficult for us to embrace it without that particular phase in life.
Probably the launch pad or the stress test.
I think.
Wakili Dan, given that, as Elizabeth makes in her submission, that this reduces or lessens the contact between people and paper in terms of going digital, then whilst that is one big advantage, and also depopulating the courts in terms of physical attendance because of the virtual court processes, what's also the disadvantage of this? What's the standing out disadvantage of this process?
Yes, I think they always say everything, has advantages and disadvantages, and we have to look at the merits so that we can actually work towards improving. So some of the disadvantages, first of all, is that in the ideal situation, we are saying we will go paperless. And I saw even the cabinet and the president announced they will go paperless. But if you look at cabinet meetings nowadays, they have the iPads there, and you still see people with pens and papers. So I think it's still an issue of our own culture. We need to have that as an idea, but we need to work towards it at individual level. Because I know, like in courts, I will tell you, as much as we are digital, we still are being forced to file, hearing bundles, hard copies. so that as much as you have filed it on the portal, if the court will still want that manual, that manual document. So they will still come in volumes. So it's still an issue of our own selves and living now towards this idea.
But the CJ says, for example, as you proceed, and how different is this? That's the question. To further strengthen these green practices, I now directed from pleadings and documents will be accessed and processed online as printing will cease from the 1st of July. Thus, no court should print pleadings and documents from the 1st of July. The resources that go towards purchase of printing paper will be used by desktops and laptops.
Yeah, and that's actually where the issue is. The courts will not print, but the advocates will be told you have to bring the hearing bundle in physical copy, so that as you are proceeding with your case, whether it's you are in your office, you can actually cross-reference. So the courts themselves are not alive to that fact that they ought to use the digital gadgets that they have to actually proceed. So we are still in that age where advocates are being told, bring these physical copies. But with time, I think that will change.
Okay.
Now, the other issue, and Dimas has said it, I don't need to belabor it, you need a gadget, of course, to access this, which is a cost, which must be there, and that's why even the CJ talks about now redirecting the funds towards this. We also have issues of the internet connectivity. The main issue or reason why some of the stations or the counties are not yet on this particular on board on this particular platform is because of the challenges that they have in terms of internet connectivity, because these systems rely heavily on the internet. But more importantly, even the system itself, currently as we are dealing with it, you have times where you are told the system is down, which happens in banks, which happens in RD House, we've seen that. So the problem is if we have system downtimes, which are more or extensive, it will then hinder negatively on the access to justice. Because it means if you have to file a certificate of urgency, the system is down, a building is supposed to be demolished tomorrow, I will be unable to file that. Previously, we could just go to court before 12 noon, you file, and you are sure by 2 p.m. You are actually in court physically to argue that application, and you get your orders that very day. Now, if you have a system downtown which cannot be controlled, even if we call my sister here, there's nothing she can do because it is controlled by other factors. You'll actually have this negating the very essence of access to justice. So as much as, yes, we are onboarding this fully, there must be a way to deal with that particular aspect. What if the system is down? What if there is an issue with the entire system itself? Will we then say that we will just sit and see people not accessing justice or not accessing the courts? That's a big issue to look at. The other aspect we need to know is that we have developed this system ourselves, and we take pride in that. But we must also be very certain that we have already ring-fenced it in a way that it is extremely secure. We have instances where, as much as Dima says we are the Silicon Savannah, it comes with a disadvantage because the same brains are the same brains which are used or who misuse that particular knowledge to hack into systems, to do things into systems without the control of the owners of the system. So we must also look at that particular aspect because once it is hacked, there'll be an issue. Lastly, there's also an issue of impersonation. You can find that if there is no proper digital coding or access, someone can impersonate. We are having issues where people are saying that you find that a case has been filed by Ayub and even amounts awarded and someone has actually been paid. Yet you do not know about that. Those are some of the things that I think if you work towards, will actually strengthen this, amongst others.
All right. When we get back from the break, Demas, I'll start with you also to further talk about also the orientation needed for judicial officials themselves, the question of cybersecurity and the data protection part of it, how the system is made immune to access from impersonation, the cases that we have had also if given the case that we heard of a lawyer who had...
not a lawyer.
Yes, not a lawyer, certainly. Because of the submissions that he made before a court of law, was not, of course, a lawyer, but the challenge is that if posed on a physical context, then how this is likely going to be, again, a buffer as to whether it can prevent such scenarios. And talk about also the access, Demas, because most Kenyans who are in prison are from low-income households or from slum areas, people who, in many cases, have no access to justice because they have no representation or can't afford that. Therefore, how will they be able to take advantage of this process? You're watching the broadcast. This is Daybreak. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. We proceed after the break here on Daybreak. Stay tuned.